Hello everyone and welcome to today's Mondac webinar in association with Patrikios Legal, who will be exploring the significance and role of Cyprus in the realm of international arbitration. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Stavros Pavlou is the Executive Chairman of Patrikios Legal. He is an experienced litigator, arbitrator and legal consultant, and he is widely regarded as one of the top litigators in Cyprus. Stavros represents an impressive portfolio of major local and international corporate clients and HNWIs in commercial dispute resolution matters, including judicial and arbitration proceedings in the courts of Cyprus and abroad. Eliana Christofi is a partner in the Dispute Resolution Department of Patrikios Legal. Eliana holds an LLM in International Business Law from the University of Manchester and an MSc in Management from Lancaster University. She joined the firm as a trainee in 2009 and was admitted to the Cyprus Bar Association in 2010, being promoted to partner in 2019. Eliana has authored and co-authored various articles on litigation and arbitration. Tatiana Maneva is a partner and head of investor state arbitration at Reynolds Porter Chamberlain LLP. Tatiana specializes in international arbitration, both commercial and investor state, and in cross-border litigation proceedings. Tatiana has experience representing international clients in a broad spectrum of disputes relating to financial services, energy, mining, telecoms, construction, international sale of goods and technology. Tatiana is ranked as a global leader in international arbitration by Who's Who Legal Arbitration 2021, 2022 and 2023, and is recommended by Legal 500 for her work in international arbitration. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we do encourage you to send in your questions. It's now my pleasure to hand you over to our panel, Eliana, Stavros and Tatiana, to begin. Thank you.
Yes, welcome everybody. I hope it's an enjoyable webinar, and my thanks go to Montag again for facilitating this. I have with me two of my favorite associates, my litigation partner Eliana, of course, but first and foremost, Tatiana, who always graciously joins us when we try to promote our little island and arbitration here. She is a big devotee of international arbitration, and we organize together some interesting events I'll refer to later. What we propose to do is that, firstly, I will let Eliana introduce us to Cyprus arbitration shortly and refer to some developments that we hopefully we look forward to having as assist in international arbitration. And then Tatiana will speak about the cooperation that we have shared for several cases and how between the UK and Cyprus we can assist each other and work on cross-border issues, and will raise some interesting developments. And lastly, I will wrap up with some reference of mine, especially on the world that we live in and how it impacts arbitration practitioners and the challenges we face and what Cyprus can do to assist us in all that. Without further delay, I'll hand it over to Eliana for her introduction. Eliana, thank you.
Okay, hi from me. Thank you for joining us to this webinar. I will start and give a brief overview of what is happening in Cyprus in relation to arbitration, its arbitration centers, and the recent changes which have been effected in our legal framework, which further support arbitration in general. So in the last decade, we have been experiencing a major push towards adopting arbitration as a dispute resolution method instead of promoting a claim in court. And the Cypriot legal practitioners have been particularly instrumental in promoting this change. Cyprus is considered to be a pro-arbitration country, and it can easily satisfy the conditions necessary for becoming an ideal international arbitration center. It is an established business center with a pool of excellent practitioners in all service areas, And due to its geographical position, it can become a neutral center where business people from different backgrounds can meet to resolve their disputes. The legal system in Cyprus is beneficial for arbitration since it is based on the common law legal system, which keeps evolving in order to be able to cater for the increasing business and commercial needs and changes. Our international commercial arbitration law is based on the 1985 ancestral model law. And Cyprus is also a member of the New York Convention for the Recognition and Enforcement of Foreign Arbitral Awards, which means that awards issued here can be recognized and enforced via a rather easy procedure in 172 countries. It also has the infrastructure to support the conduct of international arbitrations. We have many available business venues, first-class hotels, excellent restaurants, a good communication network, and 2 international airports. So in Cyprus, there are currently 4 arbitration centers, which can be used for domestic and international arbitration. There is the Cyprus Center for Alternative Dispute Resolution, the Cyprus Arbitration and Mediation Center, the Cyprus Eurasia Dispute Resolution and Arbitration Center, and the Cyprus Bar of the Chartered Institute of Arbitrators. The largest center is the Cyprus Center for Alternative Dispute Resolution, which provides also services for consumer and banking disputes with low fees for such cases. The Cyprus Bar Association and the arbitration centers are trying to make the arbitration process appealing to the parties and easy to follow. And the bar has selected a specific center with which it is affiliated. It has established a registry of arbitrators where a legal practitioner who satisfies the academic and empirical criteria set by the Cyprus Bar can register himself as an arbitrator. There are fixed rates for the arbitrator's fees. There are smaller scales and simplified procedures for small claims. There is also available a standard arbitration clause and a clause for submission of a dispute which is already pending before a court to be submitted to arbitration in order to assist the parties who wish to explore this process. Now, we also have ad hoc arbitrations, which are used due to the fact that we have a lot of experienced practitioners in all the fields of dispute resolution. So the parties can easily locate and appoint an arbitrator with proper experience who they can trust to resolve their disputes. International arbitration in Cyprus, institutionalized or ad hoc, can be very cost effective, especially in comparison with the major arbitration institutions such as LCIA or the ICC. During the last few years, we have seen many efforts from different parties in order to align the legal framework of Cyprus with the needs of international arbitration, some of which have materialized and some of which are still being developed. So we had the creation of the Cyprus Arbitration Forum, which is a non-profit NGO formed by 21 law firms with the aim of promoting Cyprus as an arbitration center. Stavros will speak about this forum and the work he does in his own talk, so I will let him expand on this. Now, there have been continuous efforts to redraft the arbitration laws, both the domestic one, which is archaic and cannot actually effectively be used to assist in domestic arbitration, and also the international arbitration law on the basis of the current business and social needs of Cyprus and following the trends of international arbitration. The new laws intend to extend their application to various types of arbitration, such as energy arbitration, commercial, insurance, consumer, shipping, and other types. There is also the intention for the new laws to address some procedural issues, which previously would hinder the registration and enforcement of awards for procedural reasons or typical formalities. And criteria will be defined as to the way which a true or authenticated copy of a document is prepared, so as to eradicate some previous inconsistent and overly formalistic approaches by the courts. In 2019, we had another court which set the record straight about who can make certified translations, so that matter is settled. But unfortunately, until today, a draft law has not been presented in relation to the domestic and international arbitration redrafting efforts. What has materialized, though, is a very welcome amendment of our legal framework, one which was long overdue and for which the Cypriot practitioners have been pushing hard for the last few years. Article 21 of the Courts of Justice law, which provides for the local jurisdiction of the courts, has been amended in order to bring it in line with the obligations the Republic has undertaken towards third countries via the adoption of bilateral or multilateral treaties, such as the New York Convention. Also, the jurisdiction of the Cyprus courts has been expanded to cover all claims under treaties, international private law, and other matters. Before this amendment, it was not clear whether a foreign arbitral award could be registered in Cyprus in the event where neither the claimant nor the respondent were resident here. There were two different judicial approaches, one which provided that the obligations undertaken under multilateral treaties trumped the domestic legal framework and its limitations, and that even if domestic laws did not explicitly provide for the jurisdiction of registration of awards in those cases, the court still had the duty to comply with the obligations undertaken under the relevant treaties, and thereby they would allow the registration of arbitral awards if none of the parties were resident here. However, we also saw the opposite approach, where courts would dismiss such applications because no party was resident in Cyprus, therefore there was no local jurisdiction. So to eradicate this difference in the two approaches and in order to honor the obligations undertaken by the Republic against other countries, and also to allow for a more flexible approach to establish local jurisdiction, the Article 21 of the Courts of Justice law has been amended, and now it provides for the following. In the event where the jurisdiction of the court, meaning here the substantive jurisdiction to decide on the specific matter, emanates from European or international or private international or any other law which is in force in the Republic, including the provision of the Civil Procedural Rules of 2023 and/or common law, the court which has local jurisdiction is a district court of Nicosia. So Nicosia is the capital of Cyprus. Therefore, if no other court has local jurisdiction, we would go to the Nicosia court. So this change has been very welcomed in that now it is clear that the registration of foreign awards will not be dismissed due to lack of local jurisdiction. We also have the introduction of the Civil Procedural Rules of 2023, which will also allow for the commercial court, once this becomes operational, to also try this type of cases. The adoption of the new Civil Procedural Rules of 2023 in September also brought changes to our procedural framework, and with their overriding objective, which is to provide the court with the tools to manage each case in a fair and expedient way with a proportional cost. So now the court has the duty to actively manage its cases in accordance with this overriding objective. And this duty explicitly includes the encouragement of the parties to use alternative dispute resolution methods and to assist them in the use of this procedure. So, for example, following the filing of the pleadings, every party has to file a questionnaire of directions, and in there they will have to set out what type of efforts they have undertaken to settle their dispute in an alternative manner. They can also request that the action is stayed in order to assist them to attempt to settle their case via ADR. And if all the parties agree to this or request for a stay, then the action is stayed for 3 months in order for the parties to explore this process. The court may also set specific time frames, a deadline for choosing a neutral persons to try the dispute, a timeline to have a hearing of the dispute, and other timelines in order to assist the parties to alternatively settle their case. The Civil Procedural Rules have also changed any application, the form of any application made in aid of the arbitration proceedings. And it has also clarified that the hearing in relation to an application in aid of arbitration or pursuant to the application laws, either domestic or international, is conducted in public. There is only an exception for private hearings in the interest of the security of the Republic or constitutional or public order or other matters. But it is not just because arbitration is treated as a private dispute resolution, then confidentiality would follow any application to the court. This will not be the case. Lastly, I would also like to talk a bit about the amendment of Article 32 of the Courts of Justice Law, which provides for the jurisdiction of the courts to issue interim orders. And following this amendment, it has now been repeated that the court has jurisdiction to issue interim orders in aid of arbitration proceedings, whether these are being conducted in Cyprus or abroad, whether they have been initiated yet or they are planned to be initiated. And the important thing is that it has clarified that such orders may be also be issued post-judgment as well. In relation to arbitrations conducted abroad, the Cyprus court has jurisdiction to issue interim orders in their aid in the event the respondent is within the jurisdiction, there are assets in the jurisdiction, or the subject matter of the remedy is within this jurisdiction, or 3, there is such a link with the Republic that the court is rendered as a proper court to hear and decide this application. So this third condition gives a bit of flexibility and leeway to argue for a link and then be able to get an order. There are no limitations as to what type of orders the court may issue. The usual type is a Mariva type of order or another order to protect the subject matter of the arbitration. Any type of order recognized under Cypriot law and under common law can be issued, which is, of course, very important because the common law is ever-changing and allows Cyprus to also follow and apply such legal developments. So we have prohibitive or mandatory orders, appointing of receivers, Norwich pharmacal orders, Chabra orders, and the basic criteria are, of course, well known, which is that you have to have a good arguable case, there are chances of success, and it will be difficult, if not impossible, to award justice if the orders are not issued. We also take into consideration whether the orders are just and equitable to be issued and the balance of convenience. Now, in relation to more specialized orders, such as the Norwich pharmacal or the Chabra orders, their criteria are usually the same as the ones provided under common law, because usually those criteria are also adopted under Cypriot case law. So that's it for me. Thank you for your time and attention to this, and I will hand you back to Stavros to introduce Tatiana.
Yes, there is already a question for Eliana. All questions will be addressed at the end and will be answered by the panelists after the various introductions we make. Please feel free to write questions and we'll take them up all as soon as the presentations are over. It's a pleasure to invite Tatiana to give her contribution to this webinar, and thank you, Eliana.
Thank you very much, Stavros, and thank you very much, Eliana, for inviting me to speak at this webinar. It's a great pleasure for me. So I was asked to speak about actually how English courts can assist in foreign-seated arbitrations, and in particular in Cyprus, since this webinar is devoted to this jurisdiction. And actually, I researched the case law, and I found out that there are actually a few very recent, very interesting cases relating to Cyprus. So let me start with the instruments that are available to parties to foreign-seated arbitrations and in England. And I would start with the anti-suit injunction, and briefly it's ASI. So briefly, it's an order of the court to stop a party commencing court proceedings in breach of arbitration agreement or exclusive English jurisdictional clause. And the basis for this is Section 37(1) of the Senior Courts Act 1981. So the party which applies for anti-suit injunction needs to prove that there is arbitration clause, and the court will most likely take anti-suit injunction unless there are very strong reasons not to do so. Anti-suit injunctions also available for the proceedings which have already been commenced. And of course, they cannot compel the respondent to stop the proceedings, but there might be great consequences. A party breaching anti-suit injunction could be in contempt of court with all the consequences like confiscation of assets, fines, and even custodial sentences. So English court, in order to apply anti-suit injunction, it has to have jurisdiction. And of course, if arbitration is seated in England, then there is no question about it. But what if arbitration is seated in Cyprus or elsewhere, let's say in Paris? Of course, there should be some connection to jurisdiction with English court. And there are cases, actually very recent cases, where English court applied anti-suit injunction in support of arbitrations that were seated abroad, and in particular in Paris. And the decisive factor was the applicable English law. So there are two cases where, actually three cases, where a court considered anti-suit injunction, and these three cases related to Paris seated arbitration. And in two cases, the court applied anti-suit injunction because it applied English law. English law was applicable to contracts. And in third case, the court declined application. So if you are interested, these cases are Deutsche Bank versus Ruschem Allianz. It was issued in 2023, and it was Paris-seated ICC arbitration. And another case with the same defendant is UniCredit Bank AG versus Ruschem Allianz. And this case, actually very recent, the order was issued on 25th of January by Court of Appeal, literally like approximately 10 days ago. And here, interestingly, that in this case, the proceedings against which the anti-suit injunction was sought, they were held in Russia. And then English court concluded, but the defendant in Russia initiated arbitration in Paris and applied to England for anti-suit injunction because, and English court considered it and applied the guidance in Anton Chubb on this choice of law and decided that English law applies because this law applied to the main contract. Another important fact when the court applies anti-suit injunction is when, another factor which court considers when applying anti-suit injunction is whether the court of another jurisdiction recognizes anti-suit injunction or can apply itself anti-suit injunction. So, for example, in previous case, which I quoted, UniCredit Bank, even though the arbitration was seated in Paris and Paris courts, they don't issue anti-suit injunction, still Paris courts in principle recognize validity of anti-suit injunction. So another case which relates to this factor is Renaissance Securities, which is Cypriot company, versus Hlodwig Enterprises, also very recent case, 2023. And in this case, the matters concerned that Cypriot company, Renaissance Security, held money and assets, securities on the Euroclear Bank account and refused to return these assets and security to the Russian companies because they were sanctioned. And Russian companies initiated Russian court proceedings. And Renaissance Securities applied to English court with anti-suit injunctions. And actually, Renaissance relied on the expert report of the Russian expert who confirmed that in Russia, under the Russian Commercial Procedure Code, Russian parties can actually initiate the claim in Russian courts if they think that the foreign arbitration or foreign proceedings will be biased or will be subject to sanctions, and the judge granted anti-suit injunctions. Finally, on the topic of anti-suit injunctions, I would like to mention that before Brexit, English courts could not apply anti-suit injunctions against proceedings in European Union member states. And because it was incompatible with Brussels regulation. However, post-Brexit, the English courts have confirmed that anti-suit injunctions is available in respect of proceedings in EU member states. And I just would like very briefly refer you to Nori Holdings Limited versus Public Joint Stock Company at Kritia Financial Corporation case. And here the underlying dispute related to allegedly fraudulent transaction where the loans and pledge agreements which secured those loans for $500 million were replaced with short-term unsecured bonds. And of course, shortly after these transactions, the Bank at Kritia went into administration, and administrator was appointed, and the administrator initiated two set of proceedings. One's in Russia under the insolvency law, and one in Cyprus declaring the transactions fraudulent. And in both proceedings, administrator requested the same relief. So respondents in those proceedings applied to English commercial courts seeking anti-suit injunction against both proceedings in Russia and in Cyprus. And in case of Russia, the anti-suit injunction was granted. And in case of Cyprus, it was rejected, even though the court said that, yes, agreed with the application, but English court said that it's actually up to Cyprus court to decide whether to stop those proceedings because of arbitration clause. So I should also briefly mention that anti-suit injunction also available to the arbitral tribunals. And in this respect, I would like very briefly touch upon one more case relating to Cyprus, and it's NDK Limited versus HUO Holding, and the case is of 2022. And this case relates to the shareholding over a mining joint venture. Joint venture was incorporated in Cyprus. And so here there was a dispute about preemptive rights, and preemptive rights were regulated by shareholders agreement and by the articles of association. And one of the major shareholders, NDK, owing 75%, initiated Cyprus court proceedings relating to violation of the preemption right. So NDK initiated in Cyprus the proceedings against defendants, other shareholders, and other shareholders initiated LCIA arbitration proceedings and requested the tribunal to apply anti-suit injunction. NDK applied to English court to set aside this anti-suit injunction under Article 67 of the Arbitration Act because the arbitration was outside of the scope of arbitration. And NDK referred to the articles of association, and in particular that arbitral tribunal acted outside of the scope of the arbitration agreement when applying the anti-suit injunction. In this case, English court was in favor of arbitration again. And very, very briefly, because the case is very complex, but English court decided that actually articles of association is it's just about registration of the right and not about deciding on the essence of the preemption right. So going forward to the next available instrument which English court can apply is, of course, freezing injunction, and it's atomic bomb of the English jurisdiction, as it's called. And freezing injunction often comes along with order for search and seizure. So the basis for freezing injunction is Section 44.3 of the Arbitration Act 1996, and here the important factor is the urgency, and actually very important in relation to arbitration is Section 44.5 that provides that the court may only act to the extent that the arbitral tribunal has no power or is unable for the time being to act. So in this respect, I would like to refer you to a case, Gerald Metals SA versus Siemens. It's 2016 case. And in that case, the court did not have power to grant the freezing injunction at the application of Gerald Metals because according to the court, Gerald Metals already had an opportunity to apply freezing injunction through application to the LCIA court, and LCIA refused. So this case related to iron ore mine in Sierra Leone, and Gerald Metals commenced LCIA arbitration against its counterpart Safeguard. And before the Gerald Metals applied to the LCIA for appointment of an emergency arbitrator and requested to freeze the assets. Safeguard responded to this application and said that it gave undertakings not to dispose any assets and also to give notice to Gerald Metals before it sells any assets in above 250,000. So in light of those undertakings, the LCIA rejected Gerald Metals' application for the appointment of the emergency arbitrator. And so Justice Legal, who considered this case, said that the test of urgency under Section 44.5 of the Arbitration Act was not satisfied. So the impact of this decision is, of course, not limited to the LCIA rules, but also extends to other rules and institutional and other arbitrations seated abroad. The next instrument which is available to the parties is compelling witness attendance and preservation of documentary evidence. And here it's very important to note that arbitral tribunal, they don't have power to compel witnesses to attend the hearing or to provide evidence. But Section 44.2 allows tribunals to permit parties to seek an order from the courts requiring a witness attendance in England and Wales to provide evidence. And recently, in recent case of 2020, the court decided to compel witnesses to provide evidence in support of arbitration seated abroad. And in this case, in particular, I would like to quote the case A and B versus C and D and E, 2020. The court decided to compel witness to be deposed in support of the arbitration seated and conducted in New York. In that case, interesting issue was whether the court should compel a party, a witness which was not a party to arbitration, and the Court of Appeal decided that in modern arbitrations a witness is rarely a party, and therefore show the willingness to compel the witness. Also mainly because in arbitrations such instruments as the Hague Convention are simply not applicable. Finally, as you see that English courts are very pro-arbitration courts, and another instrument or like opportunity which parties has is of course enforcement of awards. And England is a party to New York Convention, and it enforces in most of the cases arbitral awards, unless the tribunal was not validly constituted, or there was material irregularity, or a case was not arbitrable, or it's violation of public policy. In all other cases, it's very likely that English courts will enforce the award. So it's a very short, brief description from me, Stavros. So up to you.
Thank you, Diana. We'll have the chance of revisiting certain of the topics that you've raised in our discussion as well. I'd like to start by saying that in Cyprus we have the Cyprus Arbitration Forum, which is a dedicated body non-profit organization that is composed of 22 of the largest law firms in Cyprus and several others. And we have taken it upon ourselves to promote arbitration with Cyprus as a potential seat of arbitration or in aid of foreign arbitration. So it's all composed of arbitration practitioners and pro-arbitration lawyers that we give a lot of our free time, if we have any, to promoting Cyprus and arbitration in general. In fact, within that confine, we are the organizers of the Cyprus Arbitration Day. We held our inaugural arbitration day in last year in May. We are holding now the second one on the 20th of May. And in fact, we are working together with the Cyprus branch of the Chartered Institute of Arbitrators so that the two conferences are next to each other and people who attend one can attend the other, even with a small discount on the fees you would be paying for the other conference. Tatiana is particularly involved in this effort. She is with us on the organizing committee. She has graciously offered her contacts, experience, and fervor in promoting can I be heard?
Yes, I can hear you, Stavros.
Yeah, okay. Because we are getting a message that there is, we're getting a message that there is a problem with sound. Now, we intend to continue promoting the Cyprus Arbitration Day. We have, in fact, with us people from the Middle East, from Israel, from Dubai, from other countries, from the UK, and from Greece. We are all working together to promote regional arbitration with Cyprus as a center. Now, what I would like to focus today is, since this seminar is also on the practical aspects of doing arbitration work, we live in a world of sanctions, a world of conflict, where we have two major conflicts going on at the same time, the Russia-Ukraine war and the Israeli-Hamas war. So we are, as professionals, challenged at a huge level, unprecedented for recent years, to be able to promote the rule of law and to conduct arbitrations in this world. The various sanctions interfere with our work. For example, we are unable to offer services to sanctioned individuals who are undergoing, who are involved in arbitration proceedings. And this has an impact on the rule of law, even though it is provided in the sanctions regulations that the rule of law should never suffer as a result of sanctions. Practically, it does. We are prohibited from offering services to any party in any proceeding that is not in a member state. This is European sanctions. We recently managed to resolve that by applying for permission to participate in an LCI arbitration that should have been a no-brainer that we should be able to participate, and the regulator granted permission for us to participate. But the need to always go to the regulator and obtain permission to participate is a problem. We do not have a general license in Cyprus to represent people like there is one in the UK, and we should pursue that in order to resolve this matter. In fact, this extends to all arbitrations, not in EU, Dubai, for example, the AFC arbitrations, the Dubai International Arbitration Center arbitrations. We are facing this issue and we need to resolve it, and we need to always bear in mind that if you are asked to be part of an arbitration proceeding where sanctioned individuals are involved, you should be looking at avoiding to inadvertently break the sanctions. Then we have the anti-sanction laws of the Russian Federation, and particularly the very invasive law granting exclusive jurisdiction to the Moscow courts for litigating on all matters that would go to arbitration normally in an unfriendly country, or in any event not in Russia, in which there is a sanctioned individual or entity. So any sanctioned company in Russia can go to the Moscow court and start proceedings there, irrespective of the fact that it had agreed voluntarily to go to arbitration, because the jurisdiction has been given to the Moscow courts to take up court cases instead of arbitration. In fact, Tatiana just mentioned one case where this was prohibited by the English court. The question that arises, and we will discuss it with Tatiana afterwards, is how effective can an anti-suit injunction be when the suit is in Russia and the company is not a resident somewhere outside Russia. Another serious consideration that comes out of this is the fact that we potentially can have a Russian award, a Russian judgment, and an arbitration award on the same matter, conflicting with each other, possibly sometimes with one of the parties not participating in the proceedings, each party taking their own proceedings. And then we have bilateral treaties forcing us to recognize Russian judgments, which can cause an additional blip. We need to discuss this and resolve it. I'm not aware of any decision that has actually resolved the conflict of a judgment with an award in the context of the anti-sanctions laws of the Russian Federation. And it's a problem when anti-suit injunctions to prevent this cannot be enforced because the parties cannot be reached. They are outside the jurisdiction of the court issuing the anti-suit injunction, and therefore they are not worried of potential punishment for failing to accept the anti-suit injunction and stop proceedings. Another development, and I'm seeing this all the time, is that a lot of people are now looking at the BITs again, and the bilateral investment treaties when their assets are being confiscated either outside Russia or in Russia, and are looking to utilize the BITs for the purpose of claiming damages against the country that appropriated their assets. The sanctions, which are freezing sanctions, do not amount to an appropriation, and that's where the countries imposing sanctions rely, that it's not an appropriation. I'm just freezing the asset. It's still yours if and when the sanctions are lifted. But there are a lot of challenges by people who have suffered from sanctions, and there are a lot of challenges with the arbitrary laws passed in Russia, allowing people to be deprived of their property, to be expelled from companies, either because they are based in unfriendly countries or because they are considered to be shareholders who are causing problems to the company because they cannot come and vote if the company is sanctioned. So in fact, I'm seeing 2-3 cases right now which are related to that and refer to appropriation of property. And the BITs are being looked at. Cyprus has BITs with a number of countries. Unfortunately, we did not think to ratify the one we have with Russia. We have signed it, and then neither of the two sides ratified it. So it's not possible to use the BIT from Cyprus. But several countries are using the BITs now, and because assets are quite often held in Cyprus, the jurisdiction of the Cyprus courts to assist these arbitrations is utilized. Where does Cyprus fit in all this? We are a small country, one of the smallest in the EU, and in the arbitration world, we are not a significant player other than in aid of arbitration proceedings. I'm pitching for Cyprus to be an arbitration center, at least regionally, and Tatiana is helping us in that respect in the region for several reasons. First of all, we are a safe haven here. I mean, we do have a past conflict with Turkey and the continued Turkish occupation of a small part of a significant part of Cyprus, but it's a stale conflict. It doesn't flare up for many years now. So we are the most peaceful country in the region. Everybody else is embroiled in the war with Israel and Hamas, especially now. There was the Syria war, etc. We offer a safe haven where all these countries who have friendly relations with us, all of them, we had friendly relations with the Arab countries, with Israel, with everybody. So we can offer a good choice of a seat for an arbitration with professionals who have a lot of experience in arbitration and in assisting arbitration proceedings, with a safe legal system that is understood by most people. It's based on the common law. It's well known to common law countries, but even internationally, the principles are very familiar to international practitioners. And we have a great network of people in the international field we have worked with over decades now, because Cyprus has always been a dispute resolution center utilized in cross-border disputes. For example, like Tatiana, whom we always go to assist us in these matters, and happily work with on several issues. I don't want to take up any more of the time, especially because I want specifically to give the last 12, 13 minutes of the webinar to questions. I see that there are already some questions. One is to Eliana and has to do with the criteria for the assumption of jurisdiction by the Cyprus courts if neither of the two parties are situated in Cyprus. Elena, so nobody's in Cyprus. Why should Cyprus be of any interest to register an award?
Well, we could assume that a party will come to Cyprus to register an award because it will have some benefits received from this registration, and they would not be just going around to different countries, trying to register an award and get nothing out of it, because there is this basic principle that courts do not act in vain. So we would expect the party to come to Cyprus and try to register an award if they would get a benefit. For example, there are assets against which the award can be enforced, or the award can be used as a defense in a pending action, or something else. There will be some benefit. If there is such a benefit, then there are no jurisdiction criteria other than the fact that Cyprus has substantive jurisdiction to register the award. The substantive jurisdiction comes from the New York Convention, but also from our international commercial arbitration law, which does not put any limitation as to what type of an award can be registered, from which countries the awards issued can be registered. So there are no limitations like the New York Convention, where you would expect an award issued by a signatory country to be enforced using that procedure. And this, the benefit that I am talking about, it is expected to be an argument to be raised in such a manner in arguments, for these type of applications, because the law itself places no limitations. So that's it for that. If the question relates to having orders issued in aid of arbitration where neither party is resident in Cyprus, then there are the two specific criteria that, well, the first one does not apply because the respondent would not be in the jurisdiction. Then the other two apply, that the assets or the subject matter of the remedy are within the jurisdiction, and that there is such other link that make with the Republic that make the courts of the Republic proper courts to issue such orders. So the criteria are very broad, and now we will be able to actually assist the enforcement of awards and orders in aid.
Yeah, then thank you, Eliana. Then there's a question to Tatiana. Does the English court accept if it is if an injunction is issued against its assuming jurisdiction, despite the existence of an arbitration clause, or is it only on the giving and not on the receiving end?
I think yes, because it can't be only on the receiving end. I can't provide now particular instances, but if when the English court applies anti-suit injunction, then interesting cases which I referred to would be these two cases with Ruschem Allianz, Deutsche Bank and Unicredit Bank versus Ruschem Allianz, where court actually applied anti-suit injunctions in support of foreign-seated arbitration. So it's interesting to read these cases because there is the logic behind deciding how court treats, because in Paris court actually itself cannot apply anti-suit injunction, and they don't have instrument like that. But how the court approached that, saying that in principle Paris courts, they don't object to this anti-suit injunction. In case of Russia, for example, clearly it's another case, Renaissance Securities Cyprus versus Hlodvig Enterprises, where the court relied on the expert evidence, whereas who actually confirmed that yes, commercial procedure code of Russian Federation actually provides for the right of the parties to apply quasi anti-suit injunction, if I may call it, where parties can actually refer their disputes to Russian courts and not to foreign arbitrations. But I would be also interested to learn from you, Stavros, Eliana, how actually Cyprus court treats anti-suit injunctions, whether it can also apply anti-suit injunction against other proceedings seated abroad.
Yeah, an anti-suit injunction is primarily directed at the person of the court. So you are not actually prohibiting the court from proceeding. You are only prohibiting the person from proceeding in the court. So theoretically, it's not an encroachment into another court's jurisdiction. It's an order against the party who is promoting something in another court to stop doing so. So it's not a question of accepting anti-suit injunctions, but the fact that an anti-suit injunction has been issued by the UK, for example, would be used as part of an opposition or an application to stop the proceedings in Cyprus, or stay proceedings because there is an arbitration clause. The additional issue of an anti-suit injunction preventing one and putting to the Cyprus court that this person, this company, is in breach of an order of the court in England, which is trying to enforce the arbitration agreement, is a serious factor to be taken into consideration. It's not a binding decision, obviously. The court will exercise its own discretion in deciding, but it's a powerful argument. And in any event, the courts in Cyprus, when faced with an arbitration clause, will go out of their way to enforce the arbitration clause because they are pro-arbitration. Very rarely do we see courts ignoring arbitration awards. I mean, they have so much work in any event, they are not going to be accepting more if they can get rid of it and have an arbitration tribunal take it over. There is, Eliana, would you like to add something to this?
I agree with everything.
Okay, then there's a question. When are we likely to see an amendment of the arbitration law in Cyprus? I have to admit that I was involved in an effort to redraft the arbitration law, and we are trying to get it off the ground again. I don't expect, as Dimitris has requested us to take a position on, I don't expect to be along the 1996 Act because the UK is not a model law country. We are a model law country. and therefore our approach to the amendment of our arbitration law and to have a unified arbitration law applicable locally and internationally will more likely follow the examples of Ireland or Hong Kong, on which we started working in order to try and create a suggestion for MPs to pick up and promote us as a new arbitration law. It's a very difficult and time-consuming process, and we are lobbying also various fora and the government to promote a new arbitration law and to help in the effort of drafting one. We probably need to create a committee to handle this because it's a big task, and they need to actually decide, like they are trying to do with the Cyprus company law, to pay a fee to an outside body to sit down and draft the law. And then it will happen. Then we can come in, the professionals in Cyprus can come in and make suggestions. But I expect it to be along the model law arbitration laws adopted by Ireland, model law based arbitration laws adopted in Ireland and Hong Kong, with some good ideas from the 1996 Act, which is being overhauled now. I think it has changed, Tatiana, recently, or it's about to change.
It's about to change, and actually, we are in the process there. So, so the arbitration bill was introduced into Parliament on 21st November 2023. So we are waiting.
Yeah, there are some interesting suggestions that will resolve some serious questions of conflict of laws in the new.
Yeah, for example, I referred to the again the case against Ruschem Alliance with seated Paris arbitration, where the court applied the principle of CHAP case, and in the proposed arbitration act, it's proposed that the arbitration, the law applicable to arbitration agreement should be the law of the seat and not of the law of the main contract.
Yeah, it's a significant departure from existing principle, and it's going to make interesting reading because other jurisdictions will be applying a different test, and it is and even intellectually it's challenging to decide. I mean, if people say my country is under English law and English people are drafting in it, and then they decide that the seat is in Cyprus, to then have, or even Dubai, to go outside a common law country. And it will be challenging for the arbitration clause specifically to be interpreted under Dubai, TAFC or Sharia law, depending on the choice, and not English law where the contract was originally drafted. But it was a choice. It had to be made. At least we get away from the uncertainty of saying we should look at the circumstances and all that, and you get some certainty as to what is applicable. So when you choose English law, you are bound by, if you choose as a seat LCIA, you are bound by English law with regard to the arbitration clause. What do you think about the conflict between an award and a judgment from Russia? What are we going to do about it when they come out with a judgment which was most likely issued without in default of appearance by the defendant? The defendant has gone to an arbitration court and the respondent doesn't turn up. So we get two judgments, both of them in default. One of them registrable under the New York Convention, the other registrable under the bilateral treaties with Russia. So what do you think we should do about it?
It all depends where enforcement is going to be sought. So if enforcement is going to be sought in Russia, then I should say that then such enforcement is blocked, because you cannot go about against Russia.
No, I don't expect the enforcement to be in Russia. But if it comes to Cyprus, and one is trying to enforce the award and the other is trying to enforce the judgment, we're going to be in trouble with two different and competing international treaties.
And this is very interesting question because yes, because you have a treaty between Russia and Cyprus on enforcement of judgments.
Exactly.
This is
I
what-
don't know the answer, but it's going to make interesting topic for us to be discussing in court, and probably some poor client is going to pay vast amounts of money to resolve it. I think we are over with our timing. I'm asking the organizers.
Yes, Stavros, we've hit the hour mark, unfortunately.
Yeah, it's been a pleasure, and I hope the audience enjoyed it. My great thanks to Montag for making this happen, and my very special and warm thanks to Tatiana for adding her valuable input to our effort to promote arbitration and Cyprus specifically, and of course Eliana for always being the stalwart fish in supporting me in all this arbitration and litigation work. Thank you again, all of you, and the audience
Thank you.
for bearing with us for an hour.
Thank you, Stavros. Goodbye, everyone.
Thank
Bye.
you. Bye.
Take care. Bye.
Bye.